Distinguished guests, esteemed colleagues, members of the press, ladies and gentlemen, good evening. My name is Ben Bowling. I'm the Acting Executive Dean of the Dickson Poon School of Law, and on behalf of King's College and the Dickson Poon School of Law, it is my distinct pleasure and honour to welcome you to this discussion on Brexit, the options for EU-UK trade. In a moment, I will hand over to Professor Sir Francis Jacobs, who will be your chair for this evening, and who will introduce the panel. I want to say a few words about the school and the context. So, the King's College School of Law is one of the oldest law schools in England and recognised globally as one of the best law schools in the world. Law has been taught continuously on the Strand since 1831 and has been an integral part of the university since it was formed almost 200 years ago. The school has one of the country's most distinguished research and teaching reputations and continues to push the boundaries of academic thought and legal scholarship. I won't list all its accolades and achievements, but suffice to say that the school is rated #1 in the UK for research, with 8 out of 10 of our books rated and articles rated as world-leading or internationally excellent. We have absolutely outstanding students. They are, in a word, awesome. This evening's event is co-hosted by the King's Forum on International Dispute Resolution. The forum was created in 2015 by my colleague Dr. Holger Hestermeyer, whose seat I'm stealing for the moment, to respond to the internationalisation of dispute resolution, one of the most exciting challenges to the legal profession this century. The Centre for European Law, this evening's other co-host, was launched at King's 43 years ago, in 1974, when there were just 9 EU member states. And of course, the EU today, with 28 members, still for now, is without doubt the most advanced example of regional governance anywhere in the world. Led by its president, the former Advocate General of the European Court of Justice, Sir Francis Jacobs, also your chair this evening, and its co-directors, Professor Andrea Biondi and Professor Takis Tridimas, the Centre is a true leader in research and postgraduate study and a fulcrum for applied learning. And the Centre for European Law at King's has played a key role in informing and shaping the development of European law. The referendum vote on the 23rd of June 2016 for the UK to leave the European Union was an extraordinary moment in European history. A defining moment with massive implications for the UK and arguably the biggest political upheaval in the European Union since its inception. There was a huge amount of uncertainty. There's a mountain of legislation to climb. House of Commons researchers estimated that EU-related law materials make up at least 1/6 of the UK statute book. That excludes the more than 12,000 EU regulations with direct effect, hundreds of thousands of pages of law on everything from bank and consumer rules to police cooperation and border control. And of course, the topic of tonight's conversation, the trade in goods and services. It's been said that we are in a post-factual, post-expert society. But it seems to me that this evening will show that the expert's obituary is at the very least premature. The reports launched this evening show that there are facts, there is evidence, there is analysis, there are options, and there is real value in expertise. King's College School of Law is one of the primary academic reference points for the BBC and other organisations on this debate and is fully engaged. The role of the university is to respond to the unknown with knowledge, to respond to ignorance with information, to respond to questions with answers. The School of Law is at the forefront of EU law scholarship, and this evening you will hear presentations and a debate on the options for trade as the United Kingdom sets to leave the European Union. There could be no better venue, no stronger lineup of speakers to debate the present and future of trade between the UK and the European Union at this most critical juncture. You are in excellent hands, and I wish you a good evening of informed debate and deliberation. Thank you.
Thank you very much, Ben, and indeed that was a very good start to our evening, and we are exceptionally fortunate this evening to have such a lineup of speakers and indeed a very distinguished audience. And we're going to discuss the report, as Ben has just mentioned, from the House of Lords Select Committee on the European Union. The House of Lords, among many activities, has a renown across Europe for its reports on European Union affairs. And it's really excellent that we have this report presented by two subcommittees of the European Union Committee, and we have the chairman of both subcommittees with us this evening as our main speakers. So it's a great pleasure for me to welcome them also, and they have kindly agreed to make relatively brief observations. They will be followed by the special advisors to both subcommittees, also present this evening, and then there will be a brief panel discussion, but then the objective is, of course, to invite comments, questions, discussion from you all. So I think without further ado, I would like to introduce our first speaker, who is Baroness Verma, Chairman of the EU External Affairs Subcommittee, and she will present a brief introduction on those aspects of the report for which she was in particular responsible. So, great pleasure in inviting Baroness Verma now to speak.
Thank you very much. Thank you, Sir Francis, and thank you very much for having us here today, and thank you to Holger for making sure that we were, first of all, here on time, and secondly, that we have got such a great audience with which that we will be interacting with. I just want to start really by saying that I joined the External Affairs Committee straight after the referendum. I was a minister up until 22nd of June, and then the Brexit vote happened, and things changed dramatically in my life. But what became very evident to me was that what we needed to do very quickly, and as I was appointed chair of the External Affairs Subcommittee, was to work very closely with my colleague Lord Whitty, who's chair of the Internal Markets Committee, in getting a look at the views from business, from academics, from politicians, from parliament, from ministers, on what Brexit would mean, would look like once we'd left the European Union. And we needed to have this engagement, and we felt a quick report was necessary. First of all, to just start an understanding where we as a committee, both committees, could see value in what we could then put back to government. And the inquiry that we headed sought to really understand the possible frameworks that would come into existence for trade between us and the EU, between us and the EEA, and what would happen to the customs union, what a free trade agreement would look like for us, and how we would work if all else didn't come into fruition with the WTO. So the purpose of working together, because of course goods and services are so interrelated, was so that we could have really a rounded, informed debate and have an overview of the issues that were concerning all the different stakeholders. So my committee looked at the goods part of the debate, and Lord Whitty's at services. And what we want to do, of course, is make this a part of a series of reports that we then send to government and get their comments on it. The committees have had an opportunity to take evidence from ministers, so Lord Price and Lord Bridges, who came to us very early on after Brexit, were able to give us a very general overview of what they felt. But as you all know, the familiar line that we're getting from government is that there will be no running commentary on the discussions. And so we have really struggled hard to see what it would look like from a government's perspective. But we will have a big speech tomorrow from the Prime Minister, which will perhaps give us a bit more information. But in the meantime, what I'd like to do is just sort of go very quickly over the landscape as I see it from the report that my committee, alongside Lord Whitty's committee, did coming together. And what we found really was that there are a number of options, that those options look incredibly different, but we must constantly remind ourselves that it is also in line with what 27 other nations will expect from their negotiations with us. So we mustn't take away a feel that we can dictate the terms of negotiation, because we need to make sure that ultimately the outcomes will be the best possible deal for the UK, but in the sense of making sure that we work comfortably with the rest of the world. And a free trade agreement, as the Prime Minister has pointed out several times over, will look like a bespoke, it has to be a bespoke agreement. Well, we don't quite know what a bespoke agreement will look like. What we do know is that it's going to be incredibly complex. The Dean, in his opening remarks, did say that we've had a long-standing relationship with the European Union, and legislation is so intertwined that it's going to take a very long time for us to unpick all of that. And of course, we've also got to see how we manage it if we are going to have to use schedules of World Trade Organization, how we manage those. Because of course, at this current moment, we are in the framework with the European Union and we work on those schedules. So to be able to then translate them back into British legislation is going to be something that is going to be quite time consuming. It's going to take there's a lot of uncertainty about what it actually looks like at this moment in time. And so what we are saying and recommending that there should be a thinking for some transitional period after Brexit, where all those components, business, academics, professionals, the Parliament, are able to make sure that going forward we do have a much more comprehensive approach to what Brexit needs to look like in the end. So we think it's required. We haven't seen or heard any soundings from government that that's what they're looking at this moment in time, but we do hope that by looking at the offerings that we've made in our report, that they see value in that. We also believe that there will need to be a real uplift of government capacity internally. We think that there is still not enough people within government that have the skills that are required to do the hard-nosed negotiating, but also to do the sort of backroom work of unpicking legislation. So government capacity is going to be something that we will really need to visit. And I'm sure those of you who have looked at the report, we tried to keep the report quite comprehensive so that it was something that could reach out and start a debate that has some information underpinning it, but actually generates more questions. Because going forward, what we do need to do is have a generating of questions so that the government has got to come back and look at every single avenue. And part of our discussions as committees has been is that we do think that there has been a complete vacuum on the sort of areas that Lord Whitty will touch on in a moment, the customs union, single market access, single market membership. So I think there is a lot that needs to take place, and what we as committees want to do is to make sure that the debate going forward is a debate that has some information underpinning it, and hopefully tonight's discussion will allow us to also take a view on the sort of feelings that are with people like yourselves, so that when we are taking evidence sessions, that we're also making sure that we're responding to what we feel that government needs to be asked. We did have an agreement, Lord Whitty and I, that anything that was incredibly difficult and technical, we'd put to the special advisors, because they see this under the microscope of detail. As politicians, we do the overview, but we do have a very clear picture that what we don't want to do is to have debates in a vacuum, and therefore it is really important that we have an opportunity like this evening's, and we've had actually quite a number of opportunities to go out and discuss our report, because what we feel is that at this moment in time, the British public, more than anybody else, really do not have a clear sort of direction of travel on where this debate needs to be going. So I will leave it at that, with only one last shot. I think that for us to get an outcome which is best for future generations, we have got to be brave enough to challenge at every single juncture, whether it is within our own governments or those that we are going to negotiate with, because the world of politics around us is really moving very, very fast. And as you can see with the US and their new leader coming in next week, or the end of this week, you know, the dynamics of some of these debates are going to be completely different to when we first started, when we lost, sorry, that's my personal view, when the referendum result was announced. Apologies. Thank you very much.
Thank you very much. Thank you very much. And of course, it is, of course, an enormous value in these reports that it provides the public with detailed factual background, detailed arguments, examination of the issues. And if I may make a sort of mischievous comment on that last remark of Baroness Verma, there might be an argument for saying that it would have been helpful if some of that information and debate had taken place before the decision was taken on the 23rd of June, rather than afterwards. But I won't say any more on that. And I will only now thank Baroness Verma and invite Lord Whitty to comment from his position as chairman of the subcommittee on the internal market. Lord Whitty has been a politician for many years with the Labour Party. There is the balance there too. Formerly Secretary General of the Labour Party, and holder of a number of governmental positions in the House of Lords, and he has been for some time now chair of the Internal Market Subcommittee, and therefore the other half of the body which examined this issue in the House of Lords.
Well, thanks very much indeed. And as Sandy Verma said, our aim was to try and clarify what the options are, given the votes. And with our own personal opinion, our committees contain people who are ardent pro-Europeans and people who are pretty deep-seated Brexiteers. And she and I had to manage them, and we got a report out. So that was an achievement in itself, on time. It's 6 weeks since we concluded the report, and our main conclusion is this, that actually whatever form of future trading arrangement we have with the European Union, there are trade-offs. In other words, nothing is absolute. Take back control has to be relative in whatever form of trading arrangement we have. There is some loss of sovereignty, whether people like it or not, even under the WTO arrangements, and possibly especially under the WTO arrangements in some respects. The name of my committee, Internal Market, does demonstrate a self-evident truth that actually within the EU structures it is an internal market. And whilst a lot of the discussion over recent weeks has been access or membership of the single market, actually the EU as a whole regards the internal market as being internal, i.e. part of the EU and coterminous with the EU. Now clearly some of the options extend that somewhat. The first option that we look at is the one which we decided was the least disruptive, and that is retaining some degree of membership of the single market through the the European Economic Area, if you like, the Norway option. Now, that is probably the most favoured option of most of British industry. Certainly most organisations and companies that talk to us have said they want to retain as much of this access to the single market as they can. But of course, access is not the same as membership. Everybody has access to the single market. There are tariffs and conditions and regulations you have to meet if you're completely outside, but everybody has access. But membership gives you special open provisions. The EEA gives you much of that. In the case of Norway and the other two members, Iceland and Liechtenstein, who come via EFTA to the EEA, they have access to most of it. They are not, however, members of the Common Agricultural Policy or the Common Fisheries Policy and various other things. My own view, and that of the committee, is that there are some serious political difficulties, particularly given the government's stance, of us taking the EEA route. Indeed, recent coverage of what is anticipated to be the speech of the Prime Minister tomorrow, which may put all this discussion out of date within 24 hours, is that the Prime Minister, who in an interview last week said, we can't hang on to bits of the EU, we are negotiating from outside, she accepts that same logic, that there are big political problems because of the red lines of the government, but also the red lines of the EU, in us being members via the EEA. There are also some procedural problems. Since a lot of you are lawyers, some lawyers argue that we will, because we're already a member of the EEA, via our membership of the EU, we retain that. Others argue that in order to retain it, we would have to join EFTA. But nevertheless, a lot of commentators think that the EEA is a possible, viable option, and one which would be least disruptive to large parts of British industry. And that's argued by some politicians, a lot of people who were on the Remain side within the argument, but also some people who were on the Brexit side. My old friend Nigel Gardner had an article in the Telegraph last week. He's a Brexiteer. He was arguing strongly for the EEA option, which he defined as Harold Macmillan's Plan A, when we set up EFTA as an alternative to the EEC back 40 years ago, 50 years ago. So there are some procedural difficulties, but the political difficulties are probably the most important. That is that the two red lines which the government have insisted on, that is control over our borders on the one hand, and freedom from the jurisdiction of the ECJ on the other, are not present there within the EEA. Freedom of movement is a condition of the EEA and applies to those countries who are outside, who are non-EU members of the EEA. There are some provisions for emergency breaks, but that is an emergency break and not a continuous condition. It doesn't actually reflect any idea of total control over our own borders. So that is a major difficulty. But it's a difficulty for the EU as well. If we were prepared to negotiate on that, would the EU be prepared to negotiate at all from their absolute conviction that we need to maintain the four freedoms, including the freedom of movement of people? And people say, oh, it's conditions with political conditions in France and Germany, they're beginning to recognise that freedom of movement is perhaps not in their interests either, and therefore they might be prepared to negotiate. But actually, in Poland and most of Central Europe, there is a complete commitment to freedom of movement for their people. And 27 countries, not 3, actually have to decide this. So I think there's a big political difficulty there. With regard to the ECJ, within the EEA, the EFTA Court will prevail for non-EU members, but the EFTA Court does itself try to reflect what is the decisions of the ECJ, and whilst EU regulations might not be directly applicable in the same way they are if we were a member of the EU, then in practice the ECJ is still the disputes regulator indirectly for those who are within the EEA. So those are very serious difficulties. And I think the politics of it make it very difficult, and we will see whether the Prime Minister tomorrow actually reflects those difficulties. One variation of the EEA has been said to be the Swiss option, but the Swiss option is really a form of a free trade agreement which is multiple. They have several sectoral trade agreements and several agreements on aspects of the access to the single market. It is therefore quite a complex trade agreement, and one which has been fraught with difficulty, particularly over the issue of freedom of movement. The other thing we looked at, which would be closer to the status quo to some degree, is maintaining the UK within the customs union. That would mean we'd have common external barriers without being members of the EU. There are some difficulties with that. It would be helpful in that it would avoid huge commercial and administrative costs with setting up entirely new customs procedures. It would also be particularly helpful in relation to Ireland and the border there, although the border problems there relate more to movement of people than movement of goods. Nevertheless, it would be helpful to us there, and we know from today's news that the Irish situation will be a complication on all these discussions, even more so than we thought it was. But the customs union, of course, only covers goods, it doesn't cover services. And crucially, as far as the government's position is concerned, it will preclude us from engaging in all the lovely free trade agreements we're about to negotiate around the world. All of Liam Fox's job would disappear, and President-elect Trump would have been proved not to be able to deliver it immediately on access to the White House. So that would not work with the customs union. Nevertheless, the customs union could be maintaining for some time membership of the customs union might be part of a transitional arrangement. Because if we are into negotiating full-scale free trade agreements, similar to Canada's, which took 7 years to negotiate, we will need some transitional arrangement after the 2 years expires under Article 50 of the Lisbon Treaty. If that is the case, then one option is to retain the external tariff for some time. That may not please the extreme free traders. It may not even please the new occupants of the White House. But it would steady things down a bit for a limited period of time. But by transitional agreement, we do not mean holding arrangement, we do not mean interim agreement, while we sort everything out. We mean transition to something we know where we're going to. Transition means you know where you're transitioning, that's the word, to. And until we are clear on that, it is difficult to see how we could have a proper transitional agreement. And therefore we would revert immediately if we hadn't reached an agreement, at the end of the 2-year period, to trading on World Trade Organization terms, with all the tariffs and restrictions on trade that implies. That does not seem to us to be a sensible approach. We've set out the facts. We haven't listed precisely what our preference is, but the logic of that position does push us towards negotiating a pretty comprehensive free trade agreement, which will take time, and may be part of a wider association agreement covering things like security, environment, and so on, as well as trade. That's more or less what our report says. Look forward to other contributions. My colleagues here will add or correct to what we have said, and we look forward to your comments and questions.
Well, thank you very much indeed, Lord Whitty, and that was really most helpful introduction again to the issues that we want to look at this evening. I confess I had an itch to ask at some point the question, what is likely to be the influence of the House of Lords in this process, maybe even in relation to the prospective decision on Article 50, but also in the actual negotiations. And it would be interesting if anyone was sufficiently indiscreet to discuss that point and maybe even give some indication of what sorts of views were likely to be expressed in the House of Lords. They had the most extraordinarily interesting debate immediately after the referendum in the House of Lords, which I think, while there were widespread expressions of regret about the decision, there was a remarkable degree of consensus, I think, that it was necessary to respect the decision. So it will be interesting to know where the debate goes. But before we engage on that debate, we're going to have now brief contributions from the special advisors, and we will start with Ingo Borchert, who was the special advisor on the internal market subcommittee. He is a lecturer in economics at the University of Sussex, and previously worked with the World Bank in Washington. So without further ado, I will call upon Ingo now. Thank you.
Thank you very much, Sir Francis, and thank you very much to the King's College and the organizers for having me on the panel. Tonight I'm speaking entirely in my personal capacity. I'm not implicating anyone. I thought from a very rich and detailed report for a terse 5-minute statement, I would just pull one issue that cuts across all the 4 frameworks that the report is discussing and shed a little bit light on that. And I should say upfront that I couldn't agree more with Baroness Verma that the report is just about the right length, right, as Einstein was saying, right? Make it simple, but not simpler. I think it lays out in great clarity all the problems and the difficulties and the trade-offs, really, as Lord Whitty was saying, of each of these frameworks. So let me briefly discuss about non-tariff barriers and technical regulations. And you might say, you know, oh gosh, right, that's about sex appeal of a traffic jam. But the motivation is threefold, right? Number one, I guess it's good to bring us all on the same page on how these 3 or 4 frameworks would go about tackling these important issues. And the empirical motivation is that in an advanced economy, such as the British economy, who's producing and trading rather sophisticated manufacturers and also services for that matter, the action really is in the area of non-tariff barriers, at least as much as tariffs, right? So it's an important area to look at. How would these frameworks go about incorporating or tackling these non-tariff barriers? What could that be? Any sort of technical standard, the level of consumer protection, qualifications required for service professionals, all of that could potentially constitute a technical barrier to trade. If 2 trading nations were to address this issue for these kind of issues not to be a trade barrier, 2 distinct things would need to be addressed, and that's not wildly appreciated. The step 1 is you need to agree on the standard, right? What is the level of consumer protection? What is the admissible car emissions? And secondly, then you need to have an agreement on how to go about certifying that, testing that, and who gets to call the shots. Who's about to, who can make these, who can certify these tests. A good example is the European car industry, and that's a good example to bring because it's arguably important for the car manufacturing as an important part of the British economy. Standards in the car industry have for decades been set by the United Nations Economic Commission for Europe in Geneva, and everybody knew what the standards are. And yet, the European countries did not recognize each other's testing procedures, and that led to the car market across Europe being more or less entirely segmented, right? So for these NTBs, non-technical barriers to trade, not to be an issue, right, you need to agree on both of these aspects. And that kind of gives us a sense of what is ahead in terms of the challenge if the UK economy, as an advanced economy, engaged in all of these back and forth production processes. These issues need to be addressed. Now, for an FTA, and I take these 3, other than the multilateral framework, other than the WTO, I take the 3 principal frameworks in reverse order than Lord Whitty did. For an FTA, obviously there is duty-free access. If the UK had an FTA, perhaps a bespoke FTA with the European Union, then there's tariff-free, duty-free access, provided that product is a UK product. It meets the rules of origin, and that could be a big catch. But what I want to highlight is, even in an FTA and as much in a customs union, there will be a border post, and some inspector might roll up and see whether that product, British product that potentially wants to be exported into the European Union, conforms to technical standards, right? And if the car is not meeting the emission standards, or if you have a smartphone of a certain brand where the battery keeps exploding or set up in flames, then that product will be barred from importing. And that is true even in a free trade agreement and a customs union. And so what I want to say is that even access to the single market is subject to a lot of buts and ifs unless the two countries agree on tackling these non-tariff barriers. And the same is in principle true for a customs union, which the report discusses as one transitional option. The only difference there is, and that sets a customs union apart from all other three options, is that there aren't going to be rules of origin because there's one external common tariff policy. There's not going to be rules of origin, but still, even within a customs union, which we think is a relatively strong agreement, there can be inspections on technical barriers, right? And that is potentially as much a technical as it is a political decision on a day-to-day business. The converse situation sort of prevails in an EEA type of agreement. The European Economic Area is at its core a free trade agreement. But it has, the EEA agreement is a wrapper, a regulatory union wrapper around the EU 28 plus the 3 additional non-EU EFTA countries. And that regulatory union wrapper leads to these 3 non-EU countries to undertake that their products, everything that's being produced and potentially traded, is produced to EU technical standards. And if it does, if that condition is satisfied at the factory gate, right, then there's no obstacle to trading them, setting them in free circulation in the entire market. That's good news. If the UK would be part of the EEA, then its products are more or less guaranteed technical barriers to trade, free access. But it's an FTA, right? It will only have duty-free access if it met the rules of origin. And that is a big if, right? In a world such as cars or smartphones, there was a very nice piece in the FT the other day about Bentleys being produced, right? And a lot of attention focuses on Nissan, but that was a piece about Bentleys. And even the Bentley's bumper will, have traveled over 2,000 miles and crisscross a channel X number of times before it's eventually being manufactured into the Bentley and then potentially being shipped abroad. In such a world, meeting the rules of origin may or may not be true. So that's a big if. Well, it's not an aside, it's actually a big point, but Lord Whitty was alluding to that. The EEA is the only option of the 3 or the 4, if you included the WTO, that would encompass all the 4 freedoms of the single market. So if there were any after-sales services attached to the car, maintenance, aircraft, maintenance, all sorts of things that might either require services trade or a company's professional going abroad and fixing things, that would be a lot easier under an EEA arrangement than on any other of the other options, because even a customs union is only about merchandise goods trade, not about services, not about capital, and not about people. And again, as it becomes increasingly the case that goods trade and services trade, more and more difficult to separate, that point probably carries increasing weight. I guess I nearly stopped there, but let me flesh out 2 additional ramifications from the different ways in which these 3 frameworks go about incorporating technical barriers to trade. And that is, even if the UK were to go for a bespoke FTA, which is being rightly discussed also in the report as one of the most flexible options, and that's true, right? It is still the case. It would provide the greatest flexibility if it were a shallow FTA that only focused on merchandise tariffs, right? That's at best half of the action, right? If it's a deep FTA, and we would probably expect or perhaps even want it to be a deep FTA in order to be not too disruptive to trade, that would imply that the UK and the EU sign a range of mutual recognition agreements on a range of things, how to go about testing car standards to professional qualifications for nurses, midwives, and other service professionals, to sign a range of mutual recognition agreements. And to the extent that the UK does that, it then ties her hands in these areas, such as cars or professional services. You can then not go on and conclude third-party trade deals with other countries because you've already committed to doing a very specific thing with the EU. And that highlights the trade-off that what Lord Whitty was making between some sort of surrender of policy autonomy versus free trade. I think these deep FTAs would be most conducive to trade if these MRAs could be concluded, but then you can't go for third-party deals. A last observation is that for a range of non-EU countries, American firms, Japanese firms, Australian firms, the UK is a bridgehead into the wider European market, right? It is difficult to approach these countries with new British FTAs, and I think there's witness evidence in the report that working groups are being set up to talk to a range of countries, right? It is difficult to do so because these countries might be just sitting on the fence and they don't really know what they would be getting out of such deal until the nitty-gritties of non-tariff barriers are ironed out in the EU-UK deal. And the flip side of that is, of course, the UK would not even know what she could potentially offer those third countries unless she has concluded the deal with the EU. I think I'll stop here.
Well, thank you very much, Ingo. That was, again, extremely helpful. And we'll go straight to our next speaker, Holger. Hestermeyer, first of all, deserves the thanks of all of us for having put together this remarkable event, which is one of a series of events which he organizes in his capacity as the Shell reader in international dispute resolution. So it's excellent that he has assembled this galaxy of talent this evening, and he himself is now going to contribute, having been the special advisor on the External Affairs Subcommittee, and previously having served in the European Court of Justice with an Advocate General. So he has this special background.
Thank you very much, Sir Francis. First of all, much like Ingo, I'm speaking in my personal capacity. Any error that I make is entirely mine. Anything foolish that I say is entirely mine. If, of course, it's very smart, you might also want to attribute it to the House of Lords. It is, for someone who works in an academic capacity on trade law, still rather surprising how much the world has changed with Brexit. If I would have said tariff rate quota and rules of origin 6 months ago, that most certainly would have emptied any room. And suddenly, the rooms stay full. And I think the first thing that is important to realize is the world of trade is also a world of nitty-bitty detail. And Ingo already mentioned it, rules of origin, for example, and tariffs. Let's just say that the UK negotiates a zero tariff for cars for entry to the EU, but then forgets to negotiate adequate rules of origin, and the rule of origin ends up being 60% of the content of the car has to be British for the product to count as British. On average, a British car is only 41% British, so that would mean British cars don't profit from the 0% tariff. Or the administrative formulae, the forms to fill out are so complex that no car manufacturer can handle them. So it's a horrible world of nitty-gritty detail, and I think the report does an excellent job of setting it out and trying to inform public debate. And I think that, Baroness Verma already said it, that is very important, that there's an informed public debate, and all too often that is still entirely lacking. So I want to contribute 3 points which I think are rather important to that debate. One was already alluded to by Lord Whitty. I think there's still a misunderstanding of the nature of free trade. You can see it whenever there is entire and utter excitement of any country saying, yes, of course, we want to negotiate a free trade agreement with the UK, yet there seems to be an utter aversion against reaching deals with the EU. And the reason seems to be that we think of the EU as taking away our sovereignty, and free trade deals being good because that simplifies trade. Well, free trade deals simplify trade through obligations, through limits of sovereignty. And just some example, for example. Chinese products, are we happy for them to be introduced into our market without the UK having power overseeing whether they're safe? Do we want to just accept a Chinese examination of the safety? That's a matter for debate. You can determine that in free trade agreements. The more rules you have like that, think of harmonized labeling, no? The easier it will be to trade, the less sovereignty you have. I'm not saying there's a right or wrong in the debate. What I'm saying is there is no full free trade with full protection of sovereignty. That does not exist. The choice the UK faces is to determine the appropriate location on this continuum. And that is a choice that it will have to make, and that choice applies equally to the EU as to other free trade agreements. Related to that, the second point, FTAs too have a lot of detailed agreements, not just the EU agreements. I just brought the summary of the chapter summaries of the CETA agreement. It has 33 chapters, including everything from electronic commerce, mutual recognition of professional qualifications, temporary entry and stay of natural persons, cross-border trade and services, investment subsidies, customs and trade facilitation, and so on and so forth. Now, in those negotiations, as is absolutely natural, both countries will raise demands. The good thing about free trade agreements is usually free trade is in the interest of both parties, so they're very friendly negotiations. But both countries will make demands, and some of those demands will not be good for UK industry. So think of the US, for example. The US has a strong tradition of raising a lot of demands in the pharmaceutical/IP sector. Demands with effects on prices that will affect the NHS. Now, those demands will be raised, and the UK will have to choose which policy it wants to follow. And this brings me to the third point. Another public debate that is badly needed is which policies do we want? So far, the EU was the bête noire. We had an entity to attack. We don't like what the EU does. We want cheap agricultural products, and our farmers will do great. The problem, of course, is you have some choices, but you cannot choose all of them at once. Either you support farmers and you protect the market by tariffs, or you lower tariffs, which makes prices fall, but which will probably not be very good for UK farmers. The EU will be gone. We should no longer focus the discussion on attacking the EU in that respect, but on choosing what policies the UK wants. And that requires looking carefully at each construct and term. So let's say, for example, dispute settlement. There's a lot of criticism at the moment of the European Court of Justice, but very little knowledge of it. Every free trade agreement that I know of, almost everyone, maybe there are some exceptions, has rules on dispute settlement. Now, these rules vary widely. If you look at the WTO, it's a procedure between two states. It's a procedure in which the company that gets hurt never gets any money, nor does it get a guarantee that ultimately its problem will go away. In fact, even to go to that procedure, it will have to lobby its government to take up the case. The ECJ is a different system. You go to a UK court because of the doctrines of direct applicability and supremacy. You will win the case if a UK act was in violation of EU law. If not, the case is referred to the ECJ to determine the matters of EU law, but you as a company have a remedy. It is absolutely fine to say, that is too much. We do not want that. But we have to be aware that also is a choice with a cost attached. And it's a cost that might be well worth bearing, but it's a cost nevertheless. And it means companies will in the future have to lobby the UK government to go to dispute settlement in any free trade agreement that might come out of the process. Thank you.
Thank you very much, Holger. And now, briefly, Professor Andrea Biondi is going to speak, and he is, of course, a director of the Centre of European Law at King's College, Professor of European Union Law here, also visiting professor in other European universities, and was until recently legal advisor on EU matters to the Italian Prime Minister. So, Andrea, you have the final word for the panel.
I suffered two referenda in a short, first the UK and then the Italian referendum. Anyway, both were not exactly. Anyway, thank you so much, obviously, and then if I actually may, I would like to express, obviously, the gratitude of the Centre of European Law, the House of Lords Committee for offering, for offering the opportunity to discuss the publication of this important report. I'm sorry, I was a bit low. Now, I was asked by Holger to try to come up with some final observation from my perspective, which is obviously that of a European lawyer, a profession that's not exactly very fashionable these days. And my point is as follows. I mean, looking from the perspective of the internal market. Now, the internal market is turning 60 next March, and obviously looks extremely different from what it was in 1957, from what it was in 1973 when the UK joined the then European Economic Community. Obviously, I'm not trying to cover every single development for the last 60 years, but just a couple of points related to points already made by other speakers and present in the report. Now, the first, the big, great idea behind the common market was the fact that you had to remove obstacles on goods, services, capital, and workers. But the removal of obstacles never meant a sort of the freedom to total and unregulated trade. And I think the point, which was very well made in the report, is that obviously the EU has a very specific lawmaking competence which are there to open up the market through a process of regulation. Harmonization is about picking up 28, soon 27 different standards, rules, and through a process of deregulation, simplify trade. And at the same time, you still need to come up and decide what's the best level of regulation. So it does involve also a process of regulation, or you could say of re-regulation. Now, obviously, we are quite used to this kind of model. You might discuss whether it was good, too much, excessive, but the point is that it was quite clear that regulation was a necessary component of a successful market. And I think I'm really intrigued by the clarity. I mean, your point about, and I actually even wrote it down, page 3, the House of Lords, I think, put this very well. There's always a trade-off between liberalizing trade and the exercise of sovereignty. Page 76, the deeper trade relationship, the greater the loss of sovereignty. Big word. What I'm trying to say is that if we are going to get rid of the EU supranational regulatory model, I don't think that would actually mean that we can get rid of any form of trade regulation. Issues like consumer protection, labeling car, e-commerce, mobile phones, I mean, all these kind of issues will keep on re-emerging, and they will need to be addressed. And I think that therefore, the report is extremely useful and invaluable in reminding everyone that some kind of process of give and take will have to take place. And obviously, as Holger was saying, it's not going to be only about the kind of model, but we need to discuss the model of enforcement, how you're going to settle disputes, and so on. The second point I'd like to make is that reading the report, obviously, and thinking about the internal market, the internal market, the then common market, any other forms of trade agreement were usually quite rigidly divided between goods, services, capital, establishment, workers. Now, again, if we look at the Internal Market Act 60, I think that this kind of distinctions make much less sense than before. And I just have a couple of points. I'm sorry, but I really got a little bit of flu. In the marketplace, the real economy, I mean, how would you classify share economy, or whatever you want to call it? Are we talking about goods? Are we talking about products? What kind of rules do we need to devise in order to tackle this issue? I mean, questions about taxation, question about the use of technology that could bypass local regulations. I mean, these just things are happening now. Even if we look at the EU law side, the distinction between, for instance, services and establishment is very difficult to find. If you look at the recent case of the European Court of Justice in areas such as insurance, e-commerce, media, telecommunication, the court keeps on using service establishment. They simply conflate the two freedoms in one. And again, the same phenomenon is happening, for instance, with capital establishment in the area of company law or investment. So what I'm trying to say is that certain kind of all categories, they probably make a little bit less sense than before. So any forms of future trade agreements might need to dare to think about some innovative solutions and other options. And the very super final point, if I may, I think is also 60 years of internal market made us realize that, again, goods, services, capital, workers might be not enough. Certain kind of areas, and I'm not talking about competition law only, but I'm talking about public procurement, state aid control, might actually be an essential part of any kind of trade deal. And I was very intrigued by the comment of a Swiss colleague of ours in one of the seminars we organized, where he explained to us that the current reform of the Swiss corporate taxation system is being devised as to take into account the possible implication for, in particular, EU law and state aid control. So again, things to think about, and then some kind of lessons from the internal market could be learned. Obviously, I realize that the 30th of January is Blue Monday, and it's supposed to be the saddest day of the year. But I would like just to finish by endorsing Baroness Verma a point about, let's just make sure to be brave enough and to challenge any kind of assumptions. So I fully agree on that. Thank you.
Thank you very much, Andrea. That was extremely helpful. Very interesting contribution. Now, before we invite your questions and comments, which will be very soon, we're going to have just a very brief exchange between any members of the panel who would like to comment briefly or respond to anything that has been said. And I will ask Baroness Verma if you would like to say anything at this stage.
Well, I think we can just start by saying how complex it all is just by listening to all the different speakers. For us as committees to just get agreement to a final report took a lot of debate because it is just often tweaking of one or two words that changes the complete context of a discussion. And I think that, this evening we've seen actually very clearly that there are things that were not debated before the referendum. I mean, on goods and services, on customs union. I mean, if we went out there to just talk to ordinary people on the street, they really wouldn't have a clearer understanding of what all of these things that we're discussing tonight will have an impact on not just their lives, but on the services that they will try to purchase, on the goods that they will try to purchase. So I think it is a real debate. And when I came out of government, in fact, Eva, who keeps me on track with the committee work, I had to constantly remind myself I wasn't in government anymore, and had to keep challenging myself on these questions. And actually sit in front of a mirror sometimes and say, what is the question that I would be asking myself? And it is profound that when you really do come down to something that we produced in a very short period of time, It really is so complicated, so difficult to unthread, that I think part of the discussions that we're going to have going forward, and that we need to be asking, whatever sector you come from, is how does that implicate on you as a sector? I mean, we talked about the insurance industry. You talk about the car industry. Any service industry, I think, will find it incredibly challenging to work out how it places itself in the debate, because when it's a goods, you know what it's an item. You've got to have the rules of origin. You know where it's going to start, where it's going to finish. But on services, it becomes a completely abstract debate. So I think for me, Chairman, I think it'll be interesting to see where the questions arise after listening to the speakers today, where your questions arise from, because for us, just sitting here, I'm sure Larry and I have got a set of questions that we'll be wanting to work out how we're going to extract that information when we go for our next evidence sessions.
Yes, well, thank you very much indeed. One can see the difficulties which there will be with the services industry. And different types of services will require totally different types of solution. But of course, one could say problems with goods
as well.
are no less complex, and the examples were given before of that. So really we are faced with enormous difficulties, but I do think that our discussion this evening has already at least given us a taste of what those difficulties are, and indeed possibly some of the ways forward. Whether Borchert would like to make any comment?
Well, just very briefly, because of the complexity and because every sector is facing different issues, a lot of sectors have said we want a bespoke sectoral agreement. And that is understandable, and it may be in one or two areas that is achievable, but in general, under any of the frameworks, that is very difficult. Even the WTO framework. So, people who come to talk to us in big companies, trade associations, small businesses, want a deal for themselves, which is fairly close to what we had under the EU in most cases. But the degree to which that is going to be possible is, in my view, pretty limited. And in any case, in the services area particularly, it is differential regulation that is the issue. And actually moving to less differential regulation applies in all forms of trade agreement. Some degree of equivalence is required in almost every free trade agreement that covers services. Would you like me to just say a word about the House of Lords since you raised it yourself, James?
Yes.
I mean, the House of Lords gets involved in all sorts of ways. Of course, at the end of the day, we are not very democratic or representative or have any legitimacy whatsoever, but we are there.
And you are, if I may say so, better informed than some other parts of the system.
Well, that may or may not be true, but
It is.
at the end, we have a responsibility as part of the legislature to scrutinise government. We will therefore, and have been, asking the government to tell us where they are at any point. Now, we've been told by the Prime Minister, amongst others, that so we're not going to have a ball-by-ball commentary. I did comment to one group of ministers that that's fair enough, but we would like to know what the score is at lunchtime. And actually, we do need a report back from time to time on how far the government got. And that scrutiny we are going to assert pretty substantially. The rumours that we might actually block Article 50 are not right. I think it would be probably wrong for the Commons to do it. It's certainly wrong for an unelected House of Lords, whatever the burden of views within it to do. At the end of the day, we will scrutinise the final deal. What happens then, I think, is not so clear. But at the end of the day, it will not be the House of Lords who determines it. It will be the interplay between the Executive and the House of Commons.
Yes.
And possibly the people.
I suppose in some quarters there might be conditions or attempt to impose conditions on the exercise of the...
Well, there might be, and some of those may originate in the House of Lords, but unless they're supported by the House of Commons, they will not.
Yes, well, unless there are any other comments, Holger?
Yeah, I think I would like to combine 2 points that were made. One was challenge the assumptions that Baroness Verma made, and the other was about nitty-gritty detail. And I think the nitty-gritty detail of trade makes it necessary to challenge assumptions, and particularly, I think, the red lines that are constantly floating around, you know, no ECJ whatsoever, no money to the budget of the EU, and I think it is important for achieving the right outcome for the UK to look at each issue and to think what is the best solution for the UK rather than proceed by red lines. Just one example, there currently is an EU trademark. There are currently lots of EU trademarks out there that are granted in Alicante but are valid also for the UK. So that of course is subject to ECJ jurisdiction. So what will happen? The UK part will lose its validity. Is that an expropriation? Does anyone have to pay for that? What will happen to them? Does the UK government then grant UK trademarks? But that will make business more expensive in the UK because then the same company will have to go and get 2 trademarks. Or would it be easier to jump over the red line and say, well, you know, that's a very detailed, technical, nitty-gritty sector. And maybe it's in the interest of the UK to just say, well, yeah, that's trademarks. In fact, the UK has opted into the EU patent system after Brexit, even though there's also a role to the ECJ. So it seems that that is not entirely out of the question. And similar things, of course, also apply to budget in some areas where that's of interest and so on and so forth.
Yes. Well, thank you very much. That's also very helpful. Ingo, I don't know if you want to add anything at this stage.
Well, perhaps very, very briefly. Let me put a slightly different twist to the sectoral bespoke deals that Lord Whitty was just alluding to. I think that that's true. In certain industries, such as car manufacturing, perhaps are especially vocal in the British economy, you know, by virtue of the number of jobs they command. Surely it will be incompatible with the UK's multilateral commitments under the WTO to go for 1 or 2 or 3 sectoral deals, because that would then probably be subject to offering that kind of treatment to everybody. That's called the most favored nation policy, right? That can a violation to most favored nation, meaning, you know, a preferential treatment between the UK and the EU, can only be justified if it's part of a comprehensive agreement, both in goods and in services. So just picking individual sectors is not going to work. If anything, you know, a whole raft of sectoral deals, that might then work if we bundle it together. But individual ones certainly wouldn't. A different aspect to that is that trade policy making is always subject to certain well-known political economy forces. And it might not be the baddest choice to surrender part of your trade policy to a supranational entity, because then, you know, the doors is a little bit less open for protectionism. In an environment where the trade policy, you know, suppose it could, the UK government could entirely redo its trade policy from scratch, right? It would not be bound by a number of the rules that form part of the single market, and some of which were probably there for a good reason. Let me conclude by saying that the report also, I think, does a fantastic job in charting out some of the implications of that. And I'm thinking of rules of origin, as Holger was alluding to. Whatever trade arrangement, whatever trade framework we will eventually end up with, right? Unless it's a customs union, there will be some form of rules of origin. Now you can ask, what are the implications for the UK economy? It's not monolithic, right? There are small firms, there are large firms, there are capital-intensive firms, there are labor-intensive firms, and you could, if you thought that rules of origin are sort of a fixed cost, right, then it might be easier for the large firms to shoulder these, and the implications of transitioning into a regime that then has rules of origin, might be a little harder for the small and medium-sized enterprises. I think all of this comes out quite clearly of the report, and that is of immense value.
Good. Thank you very much again. And that's, again, I think, a useful clarification. We now move on to the next stage. We invite warmly your comments and questions. Time is moving on. I notice that we're on European time here, but that's quite appropriate. But nonetheless, if you would like to speak, please just identify yourself, name and affiliation. Yes, please.
Thank you. I'm Dan Roberts from The Guardian. Thank you for arranging this very timely. One of the issues that was dealt with in the Lord's report, but got a little less time tonight, is the falling back on WTO, sort of walking away from any attempt at a bespoke deal and simply relying on what's already there on the WTO tariffs. If we're to believe that the clean Brexit that some in the Tory party are proposing at the moment, it kind of assumes that that's the end state. And I wondered what the panel thought about A, the likelihood of that being where we end up, given all the difficulties you've identified tonight, and B, if that is where we end up, what will it do to British economy?
Do you want me to?
Please.
Okay. Well, I think politically it is quite conceivable that we will end up there, because we rule out all the other options, or the options are too difficult. And there are certain people within the government, and even more within the media, not including The Guardian, obviously, who want us to be there. So, and anything that is short of that is prevaricating and compromising. So we might politically and sort of culturally be at that point. What we have to recognise that even if we're operating under WTO rules, there will be some rules. There will not only be a disputes, a weak one, but nevertheless a disputes resolution thing, but there will be rules which require some degree of equivalence, which will not be entirely determined within the UK. So if we're kidding ourselves with one bound we will be free, or the EU can kick us out and we're laughing, then you're not. You've still got rules.
Yes, thank you. Anyone else like to comment on that? Holger.
I'm not an economist, so I can't do any predictions. I mean, the first thing is, of course, people trade from outside free trade areas all the time, so it's possible. The second is this has been an integrated area for decades, so it's going to be disruptions, and it's going to be disruptions in a lot of different complex ways. Administrative requirements that people are not aware of, ways to handle trade, just border inspection posts for animal products. Again, the nitty-gritty details. Tariffs will happen. In fact, if we fall back on the WTO option, if the UK imposes tariffs on third countries, it has to impose tariffs on the EU. So the option of voluntarily not imposing tariffs, that is sometimes mentioned, does not exist. That's WTO illegal. So I don't think the tariffs are going to destroy everything. But if we speak about integrated product chains that cross back and forth and that end up being imposed tariffs on several times, that is going to be difficult. So I think it's more about disruption than disaster, and a lot of administrative difficulty.
I think, can I just add, I think we really do underestimate the amount of administrative burdens that will be placed on not just British business, but on everyone who will be wanting to work with us, with trade with us. So I think the arguments have been made so simple and so simplified around tariffs and the burdens on tariffs and the restrictions that we will face through the schedules, and there'll be a number of schedules that we'll have to try and transpose into UK ledge, that will ultimately again restrict us from the very options that we're trying to say that we're freeing ourselves up from. So, you know, I think we've got to really go out there and demonstrate how complicated it is going from one system of leaving a supranational into another system, which is equally, I think, as cumbersome and as burdensome. So I think the debate is rightly going to be one of how do we get the understanding of these implications on it.
But of course, it's also the process of setting up the system, which means that all that level of complexity arises now, so to speak, rather than something which has been developed over a period of time.
And would that bring certainty to business, you know, ultimately?
Ingo.
Could I add one point to each of the scenarios and the points raised by Holger and Baroness Verma? Yes. The question initially was, what would you do to the British economy if we fell back on WTO? You know, I can't give an answer in terms of levels, but what I can say is that the rules under the GATT for goods are a lot more detailed and slightly more binding than under services, under the GATTs. So if anything, that's for sure, right, that the disruption or the impact might be a lot more disruptive or much more felt in services and movement of people than in goods. There's something, you know, commitments, legal commitments under the WTO are cast in terms of bound rates. It's a rate above which you can't go. But applied rate, MFN rates, are often a lot more liberal, right? And that's called water in the tariffs. And for goods and advanced economies, that's relatively narrow, right? But for services, that binding overhang between GATT's commitments and what is actually an applied services trade policy for investment and people, that's huge, right? So the ramifications would be a lot more for services than for goods because of the differential size of the binding overhang. A different point is, how do we get there? That's actually admittedly a point where I thought, oh, that's easy, right? You just need to take the EC's schedule, the European Community schedule. Even in the simplest case, let's just forget about the agriculture and the tariff rate quota. These are acknowledged, potentially difficult points. But just take a goods tariff for cut flowers or whatever. Now you delete EC and you copy-paste UK on top of that schedule, and you thought that's fine. It's going to be the same tariff rate of 5% before and after. But it's not in a world of back and forth trade. Rotterdam is a huge port, right? A lot of stuff goes into Rotterdam and is then being transshipped to other destinations. If the UK breaks apart and now the EC has a 5% tariff and the UK has a 5% tariff, right? Stuff going into Rotterdam and then being transshipped to the UK pay 5% twice, and that's not the same. And that closes down, that could potentially close down that relatively easy, light touch route of rectification. So even what I thought is relatively straightforward might perhaps not be.
Thank you very much. Yes, the gentleman there.
As I understand it,
Can you just give your name?
Neil Sinclair,
Thank you.
of no organisation, private individual. As I understand it, it's not permitted to the UK to negotiate a trade treaty while it's still within the EU, which therefore means that the discussion which Michael Gove had with President-elect Trump, to the effect that we will quickly have a US-UK treaty, is not correct. It can't be correct. And indeed, negotiations, which will take some time, can't start until we have actually left the EU. So what happens in the interim?
Well, I think, if I may make a comment on that, I read this piece and the impression given was that it was going to be signed and sealed next week. And I think one has to take that with a certain pinch of salt. Others may have a different view.
No, I think you're right. We are able to discuss and explore, but we can't sign.
Yeah.
Or negotiate. And so the discussions Mr. Gove has prominently had will be negotiations that the government will have and not Mr. Gove.
Yes, please.
Home Secretary in capacity, just to follow up on that, is there in fact any sanction to stop the government negotiating on something which is after all matter of
Holger, I'd like to answer.
I think before we get to the legal technicality of is it allowed to negotiate, I think we also have to look at the practical technicality of negotiating. And I am not sure how that would work, because trade negotiations work like that the US will say, we see this is your tariff rate quota for beef, we want this and that. Now they would say, we see, no. What is your policy on this? We haven't decided yet. What is your policy on that? Well, we're still negotiating with the EU. So I think quite beyond the legal aspect of is it allowed to, there's the technical aspect of does it make sense for anybody to commit thousands of man-hours on a negotiation where you don't have the starting point?
And isn't it also arguable, I don't know, arguable that the future agreement between the UK and the EU would have to be final before it would be sensible to negotiate?
That would be the implication. So the legal question is the common commercial policy is an exclusive competence of the EU, so accordingly only the EU can do that. But that is the legal matter. The then technical matter is, even if we wanted to negotiate, could we meaningfully negotiate until we have a final deal or some form of agreement with the EU that allows us to say, well, this is our starting point?
That said, is there any sanction?
Okay, so the sanction. What would happen, let's say, for violating the exclusive competence? The Commission could start an infringement proceeding, and there can be sanctions at the end of that.
But also, I think the agreement with the third country would be contrary to international law, because it would involve discrimination between the EU and the third country.
Well, let's say the agreement comes afterwards, or not. Or do you even mean signing the agreement? That would be very difficult to do in 2 years. So,
yes, please.
I mean, the simple answer from me would be that what we're trying to provide the government are scenarios, and from the evidence we're taking, what that evidence gives us as a complicated scenario to work within, or something that the government can go back and see how they can accommodate our sort of suggestions. But ultimately, it's for the government to decide. I mean, the government hasn't really, and I'm sure Larry would agree with me on this, hasn't really come forward with any materials that we can say that this is a starting point for us as a committee, as committees, that we can go back and say, these are the evidence sessions that we've gathered. Have you worked with our suggestions? So we're waiting for tomorrow's big speech, actually. We're hoping that this big speech is going to lay out a working skeleton for us to go back and organise our next evidence sessions on.
You will, in fact, carry out a further study.
We're doing one on goods and one on services now in more detail.
Yeah.
We are only 2 of 6 committees which are looking at different aspects. We've got looking at justice and home affairs, required rights, the environment, etc.
Yes.
So all of those things have to come together. That is why the House of Commons has voted, and we recommended, that before Article 50 is triggered, there should be a description of what the government are aiming for. That's not. Some people interpret that as legislation. It may be a 3 or 4 page bill, But actually, they've got to lay that out before the end of March. At that point, we can start saying, well, within that, this is what you need to do. At the moment, we can't say that.
Holger, did you want to say something?
Yes, I'm here too in a personal capacity. But for such a monumental decision, and I don't want to prejudge what the Supreme Court says, but shouldn't Parliament go further than that? Because what I'm a bit afraid of is that the government maybe tomorrow will set out a strategy. We think about our Brexit, not EEA, not these other things. But shouldn't all these issues be discussed fully in Parliament? After all, this is affecting 43 years of legislation when every political party was active. And then, for example, just to give an example, it's probably not sensible, but you might say, oh no, wait a minute, let's have a look at EEA and let's see how we can mitigate immigration, either through the break, or can the EU promise to introduce some new mechanisms for immigration? Can we mitigate the European Court of Justice? Is the European Court of Justice so very bad in actual fact, in terms of trade decisions? So what I'm saying more fundamentally is, should Parliament be involved to the fullest extent? Of course, it will depend on what the Supreme Court says. But
Well, the Supreme Court is adjudicating that there needs to be a parliamentary discussion. But they're doing that on the grounds that the treaties, of the European treaties, bring with them acquired rights and other rights. And that is a matter of UK legislation. The right to make treaties, however, in this country without a written constitution is exclusively the right of the executive. It is the royal prerogative. Now, whether I should be defending the royal prerogative, I don't know, but that is the case. So at the end of the day, the government have that prerogative. Now, they then, in Parliament, decided to hand over the choice to the people, which was allegedly an advisory body, but politically they said they would take note of it. They needn't have said that, but they did, all parties. That means that arguing the basis of it is probably not an option. Arguing the detail and where we want to get to, yes, Parliament now, as a result partly of the High Court decision, partly of the motion in the House of Commons a few weeks ago, that will require us to have a pretty heavy debate at the end of February through to whenever Article 50 is triggered. But the central decision has been taken. We could have another debate with possible further ramifications when the deal is clear. But in between that, it is scrutiny of a power which the executive have.
But there will be endless scrutiny.
Yeah.
I mean, there will be endless scrutiny. I mean, you know, Larry's absolutely right. The difficulty, of course, is we are now in a place where we really have got to make sure that whatever the outcomes of the Supreme Court is, that we do have the level of scrutiny that that parliamentarians were fearing that they wouldn't have access to. In fact, to be quite frank, I don't think there's a day that goes by when we don't get questions around Brexit in the House of Lords. I don't know about the Commons, but definitely in the Lords we have it on a daily basis. So it's being aired thoroughly in the Lords.
The question at the back, please.
Agree. I'm a lawyer, and actually I'm with the case, but that's another subject. I was going to ask is to what extent is the government listening? Because, as you say, for the government, a rather simple picture is the easiest, and the Lord's report and other reports, and all we say, add complications. Indeed, we say that this is a very complex situation to deal with. We've got 40 years legislation, we've got different views from different sectors as to what the future holds. And to what extent is the government going to listen to what others might say because of that problem? Whereas for the government, the more you introduce the complications, the more difficult it becomes, the less able are they to deliver the message, which is Brexit.
Well,
Try that one.
my simple response is they don't say anything. I mean, you know, we've had nothing really of substance that we can actually say this is too complicated for them, because they haven't said anything. Larry?
Well, I think there is no doubt the government understand the complications. They are engaging with all parts of British industry on the trade issues and with other civic bodies in relation to other aspects of the relationship with Europe. There's a massive amount of work going on, and every person they talk to outside is going to tell them how complicated it is. And most of them are going to say, we want the closest possible to the status quo. But at the end of the day, the government are bound by this decision, or consider themselves bound by this decision, for the moment anyway, and they are therefore trying to make sense of it and come up with what their option is, and they must do that within the next few weeks. But there is one other little intriguing aspect as a lawyer of the what is now a Supreme Court case, which is whether or not the Article 50 process can be reversed. Our legal advice, including that from John Kerr, who actually wrote, as a member of the House of Lords and actually wrote Article 50, is that it can be reversed, because it doesn't say you can't. But both parties to the High Court case accepted that it was not reversed, and therefore the judges did not adjudicate on that. Were the Supreme Court to decide it cannot be reversed, then we are in a different situation, because that means challenging at the end of the deal becomes impossible.
I think that's a difficult argument to reverse the certainly first instance and indeed the Supreme Court. All parties accepted, the courts accepted that it can't be reversed. You actually don't have an Article 50 case if it can be reversed, because the whole case is based on the service of the Article 50, because it cannot be reversed, affects the rights immediately. So neither we as claimants nor the government would say that it could be reversed. I think it would be difficult now to litigate it, because Biondi said that you should have litigated it back then.
That is possibly true.
Now, indeed, there was a third-party intervener, an individual who sought to raise the point, but was batted down, and therefore it wasn't in front of the court. I mean, there is that Irish case.
Yeah.
May raise it. I think that's difficult, but they may raise it.
Yes, please.
I just have one quick question. In free trade agreements, there's a lot of different provisions, and some of them have to do with trade, but they also have to do with movement of people. For example, when the U.S. negotiated a free trade agreement with South Korea, they had to overcome they had to meet certain standards for visas, and they had to have so many people that didn't want to stay because they loosened up and had visa waiver. Once you kind of get past Brexit and start doing free trade agreements, how do you decide how to deal with that movement of people, given that that was the reason for Brexit in the first place?
Can you repeat the question?
In free trade agreements, there's a provision for movement of people. It's a big issue, and it's a big point of negotiation. And once you start doing those free trade agreements, I mean, how will the government deal with that aspect? Both policy-wise and publicly.
Yes, I think the question is, you may have to deal with free movement of persons under a free trade agreement. How are you going to be able to deal with that, given that the control on immigration was fundamental to the idea of Brexit? That's essentially the question. Yeah.
To some extent, I feel you know the answer to that. The way it works is let's say in trade negotiations with India, because this is where it's going to be raised, for example, but also with China, India is going to say, we want more visa. And then there's several possibilities of reacting to that. You can either say, well, instead we want to give you this and this and that, and maybe India accepts it. But if India insists, you'll just have to choose. And if India then says, then you won't have a free trade agreement, then you have to choose whether you want that free trade agreement or not. It's that's the way it works in the end. But you're absolutely right that a lot of modern agreements, I mean, CETA has a provision on individual entry. I think I once looked up the China-Australia one, which had a provision for visas on Chinese cooks, for example. So it can be rather specific.
Yes, they're the unique skills. Yes, please.
John, two points. First of all, if you have a transition agreement, this presumably would not fall under Article 50 to be dealt with as a QM CAS that would have to be ratified by the board remaining 27. Secondly, when the Prime Minister saw this out back in the autumn, she seemed to give assurances that she was satisfied with this, which presumably meant that she was assuring them that there would be tariff-free access to the single market with no non-tariff barriers. Finally, no one's mentioned Mexico's Albania option.
Mexico's Albania option.
Yes. I think probably Michael knows more about Albania than I do. Yeah, I mean, nobody knows what the Nissen deal was. That's part of the problem. Clearly, Nissen were given certain assurances, but they may have been compensation in ways which might, under the EU state aid rules, be dodgy, but wouldn't necessarily be dodgy under UK legislation, and would probably be delivered, for example, in R&D activities or regional grants or whatever. It's a compensatory, almost certainly a compensatory thing, not that they could absolutely guarantee there would never ever be any barriers, either tariff or non-tariff. But we don't know. As to Albania, one of the points is that all these Eastern and Central European countries have some form of association agreement which presumes they move closer towards the EU, not further away. We looked at the Ukraine agreement, for example, which at the moment nobody's actually going to allow Ukraine to join the EU, but the Ukrainians have certain assurances they could be closer to the EU for both economic and strategic reasons. An association agreement of moving further away in the EU is also possible because that covers not only trade but all sorts of other activities like human rights and security and so forth. So a broader agreement is a possibility.
Well, we still have a lot of questions, and we may go on for...
We have to wrap up to go to the reception.
Very soon.
Yeah.
Maybe
another 2 questions.
When you take all the questions, take 2 or 3 questions at once. Yeah.
Maybe that's a good idea. If we could maybe take those 3, and then, well, if it's a short question, maybe a 4th. And I think we have to stop there. And we'll take those questions together, if we may. Yes, please, if you'd like to start. Yeah.
I'm Chris Snopoulos, I'm from Dartmouth University. I would like to ask 2 questions. One is about supply chains, and that's my sort of field. And coming up to the distinction you made about value on services versus products. And of course, one of the things that integrated supply chains do a lot these days is that they try to bring the two together. If you see it, for instance, buying a car, you buy a car, you mentioned that very briefly in your example. You buy a car with a warranty, you buy a car with finance, yeah? So when you buy a car, and all these things come together. But then you have to separate them at the different options you have there. I guess what's the panel's view on that? And the second, slightly more personal question is that one of the paradoxes of me living in the northeast of England is my son plays football right next to the Nissan plant, yeah? And it's quite interesting that people that are no voted against the EU are the ones that are largely likely to lose out more, for instance, from a bad deal. And I guess one of the big issues in the whole campaign was how this complexity of the message was communicated down to the people that eventually voted, and potentially now that any trade deal might come through, how any complexity is going to be communicated to people to tell them that any trade deal is good now, given the fact, as you suggested, and I very much agree with you, that sovereignty will have to be given away. So what's the panel's view about communicating these complexities down to people who potentially benefit or lose out from this?
Thank you very much, yes. And there were 3 others? Yes, please.
Nick Marcos from the Commission. My question is most for the speakers from the House of Lords. From your consultations that you've had, which sectors have been the most vocal in society? Which industries?
Yes, thank you. Yes, the gentleman here.
Yeah, I'm interested because there's already parts of the EU that have got separation, had so since 1972, which is the Channel Islands and the Isle of Man. And there hasn't been any discussion really about that, but it's an interesting comment that there is already actually a model in part of the EU, part of the UK, for separation from the EU that operates in those areas.
Yes, indeed. Yes, at the back there, please.
Whatever the trade agreement that is reached, is there not a major risk that businesses in the UK want to leave in order to avoid costs? And in that case, has the government developed a strategy of incentives to keep businesses in the UK?
I'm not sure I quite gather that, but maybe our speakers have gone to say. If not, we can get back to you. Yes, one more, and then we'll stop there.
Which are the most significant benefits the service sector would lose by leaving the EU apart from passporting?
Well, thank you very much. I think those are really quite limited questions in scope, at least some of them are. And maybe we can just take them quite quickly. I think we have the first question about supply chains. I'm not sure we have discussed complexity quite fully, I think, already, the complexity of this.
I'll just respond on the messaging. The referendum message for Brexiters was an easy one. I mean, it was just very simple. And the result was got our country back. I didn't quite know what it meant, but that was... And I think the difficulty, of course, has always been that the referendum, and if we talk about the North East, the referendum was based around issues that were beyond, really, the EU. I mean, they were largely on control and immigration, and they were simple messages. And so to try and then win referendums that tell a complex story are very, very difficult. But the sectors that I think that have been most vocal in our committee evidence sessions have been ones that have got the scale to go to government and frighten government. So Nissan was a prime example of that. And we've had other sectors coming and saying that they are also looking for those sort of separate deals, but we don't actually know what the deal is. And so these sectors don't actually know what it is that they're asking for either. What we do know is that when we were taking evidence from them, that they were resolved to the fact that we were going to leave the EU. What they now needed to know was how they were going to minimise the costs that were going to be incurred. So they've already got an undertaking in their own thinking of future planning that the costs are going to increase. So I think, I mean, I'll leave the other sort of questions to other panellists, but I think it's important that when we do discuss issues, which is why we worked really hard to make our report accessible to everyone, is so that we can have a debate which we should have had before the referendum.
But any option remains complex. That's
Yeah.
So,
Yes, I mean, we can all, in retrospect, criticise the referendum campaigns, both over the oversimplification by the Brexiteers and the complete failure of getting the message across by those who wish to remain, and indeed using economic data to frighten people, which was not credible and actually is already proven not to be credible. So I think that campaign was disastrous, but that happened. And we are now in a situation where we have to make the best we can of it. In relation to the industries which are coming to us, a whole range of industries, but they are mainly larger companies or companies which are well organised. And some of them come to us and say, well, we minimise it because we can do a separate deal. The audio-visual industry says, we're under we've got a separate directive, we can stay party to that directive, we'll have to pay a few bob into the coffers, but actually it'll be all right because all our colleagues in the continent want us to stay. Well, it ain't going to work like that. But it is the well-organised industries, but also, probably not surprisingly, the professional services. We're now focusing on services, and the most important things to them are mutual recognition of qualifications for health services, for lawyers, for accountants, for that whole range of personally delivered services. And the universities, of course, are pretty key in this, and the universities' lobbying is actually pretty intensive. Not as well focused as perhaps it should be, if I can hint at. It is there, and it has registered, certainly with us in the House of Lords, and I think there's appropriate ministers to a degree, but keep it up.
Very good. Well, thank you. I think we should stop here. It's really been a marvellous session. I think we are enormously grateful to our speakers. It's been wonderful to have such superb accounts of the issues that arise, these very difficult issues, explained in a way which really makes it possible to have a sensible discussion. It shows us also, if I may say so as well, that the House of Lords is doing a remarkable job on this matter. So, enormous thanks to our speakers, to Holger for arranging this evening, to you all for taking part. Thank you all very much indeed.
Thank you.